The House to begin in committee on the Online Safety Bill. Lord Parkinson of Whittleby.
My Lords, I beg to move that the House do now again resolve itself into a committee upon the bill.
The question is that the House do now again resolve itself into a committee upon the bill. As many as are of that opinion will say content. The contrary not content. The contents has it. In Clause 11, resume debate on Amendment 33B.
My Lords, I rise to speak to Amendment 155 standing in my name, and I'm grateful for the support of the noble Baroness Lady Fox of Buckley and my noble friend Lord Strathcarron. Some of my remarks in committee last week didn't go down terribly well with all members of the House, and I realise, if I may say in retrospect, it's because I was, I think, the only member of the committee that day who didn't take the opportunity to congratulate the noble Baroness Lady Kidrell on her birthday. So may I, at this very late stage, possibly a week later, make good that deficiency and hope that in doing so I will get a more jocular, a more welcoming hearing than I did when I spoke last week, though I will speak in a similar vein, though on a different topic and part of the bill. This amendment relates to Clause 65. Clause 65 has 12 subsections to it. The first I regard as relatively uncontroversial. It imposes a duty on all service providers. The effect of this amendment would be to remove all the remaining sub-clauses, which fall particularly on service on Category 1 providers. What Clause 65 does, in brief, is to make it a statutory obligation for Category 1 providers to live up to their terms of service, though it does not seek to specify what the terms of service must be, although it does in some ways specify how they should be operated once they've been written, which I regard as very odd, and I'll come back to why. But I would like to say at the outset, I do understand the motivation behind this section of the bill. It is the feeling, the understandable feeling, that if a service provider of any sort says that they have terms of service which mean that should there be complaints, they will be dealt with in a certain way, to a certain timetable, you will get a response by a certain time, or if they say that they're going to remove certain material, that they should do what they say they're going to do in the terms of service. So I understand what the clause is trying to do. It's trying to oblige them to live up to their terms of service. But this is a very dangerous approach. First of all, terms of service are a civil contract between the provider and the user, but they are not an equal contract, as we all know. They are written for the commercial benefit and the commercial advantage of the companies who write them. This is not just in the internet world, this is generally true. And they're written on a take-it-or-leave-it basis. Of course, they cannot be egregiously disadvantageous to the customer, or the customer probably wouldn't sign up to the terms of service, but nonetheless, they are drafted with the commercial and legal advantage of the companies in question. They can be extreme. Noble lords may be aware that, of course, if you have a bank account, the terms of service that your bank has effectively imposed on you almost certainly include a right to close your bank account at any time they wish and to give no reason for doing so. I regard that as an extreme term of a service provision, but it's common and it's there. So they're not written as equal contracts between consumer and service provider. Why, therefore, would we want to set them in statute, which is what this clause does, to make them enforceable by a regulator under statute? Even more so, why would we want to do it when the providers we're discussing in practice will have drafted their terms of service almost certainly under the provisions of a foreign legal system, which we are then asking our regulator to ensure is enforced? My objection is not to trying to find a way of requiring providers to live up to the terms of service they publish, and indeed, through the normal process for doing so would be by way of a civil claim. It is the method of doing so in this section that I object to. And we do not use this method with other terms of service features. For example, on data protection, we don't have a regulator who enforces terms of service on data protection. We have a law that says what people must do, what companies must do to protect data, and then we expect them to draft terms of service which are, and to conduct themselves in other ways, that are compatible with that law. We don't make the terms of service themselves enforceable through statute and by way of regulation. But that is what this bill does. And when we look at the terms of service of the big providers on the internet, the sort of people we have in mind for the scope of this bill, we find that they give themselves in their terms of service vast powers to remove a wide range of material, much of which would fall, if I don't want to be controversial, but would fall into the category legal but harmful, which in some ways this clause is reviving through the back door. And what, of course, could be harmful is extremely wide because it will have no statutory bounds. It will be whatever Twitter or Google say is something they will remove in their terms of service. We have no control over what they say in their terms of service. We don't purport to seek such control in this bill or in this clause. Twitter policy, for example, is to take down material that offends protected characteristics such as gender and gender identity. Now, those are not protected characteristics in the UK. The relevant protected characteristics are sex and gender reassignment in the Equality Act. So this is not enforcing our law. Our regulator will be enforcing a foreign law, even though it's not the law we've chosen to adopt here. YouTube policy during the pandemic prohibited material that contradicted the views of health authorities. Even my right honourable friend David Davis was removed for opposing COVID passes, but that was a legitimate political position to take and a contribution to make. And there is no obligation on the platforms to protect free speech or to have respect to Article 10 of the European Convention on Human Rights. They're not in any sense bound by the European Convention. They're not, most of them, in any sense European. I do think very strongly that this whole section is a very dangerous one. I posit an extreme case. It does require a slight exercise of the imagination. But imagine a Russian platform were to gain a significant presence in the UK. It's not impossible. Nobody would have predicted TikTok emerging from China so quickly not very long ago. Imagine the terms of service said, quite in compliance with Russian law, that they would remove any material that included the word war and Ukraine together. Special military operation would be all right. War and Ukraine would not. Imagine that they were relatively inefficient at doing this and they left such material up. Are we not in a position as a result of this section of the bill of obliging OFCOM to seek to enforce that term of their service contract on a Russian platform. How absurd would that be in an extreme case? But the parallel exists with the American and other platforms as well. I very much hope that my noble friend would say what I want to say, which is that, yes, there is an issue. We would like to do something. We do understand the motivation here. But this is very much the wrong way of going about it. It's inimical to free speech, and it leads to absurd conclusions.
I rise to speak in support of Amendment 44. I am pleased that as part of the new Triple Shield, the government has introduced Clause 12 on user empowerment duties, which will allow users to protect themselves not just from abusive posts from other users, but from whole areas of content. In the Communications Committee digital inquiries, we have plenty of evidence from organisations representing minorities and people with special characteristics who are unable adequately to protect themselves from the hate they received online. I'm glad that there's subsections 10, 11 and 12 recognising specific content and users with special characteristics who are targets of abuse and need to be able to protect themselves. But subsection 3 requests that these features should be designed to effectively reduce users encountering content they want to avoid. I'm concerned that the interpretation of effectively will be interpreted subjectively by platforms in scope. Each will interpret effectively in a different way. At the moment, it will not be possible for OFCOM to assess how thoroughly the platforms have been providing these empowerment tools of protection for users. If the features are to work, there must be an overview of how effective they're being and how much they're working. When the former Secretary of State, Michelle Donnellan, was asked about this, she said there was nothing in this clause to pin an assessment on. My Lords, it seems to me that the lists in Clause 12 create plenty of criteria on which to hang an assessment. The new duties in Clause 12 provide control tools for users against very specific content that is abusive or incites hatred on the basis of race, ethnicity, religion, disability, sex, gender reassignment or sexual orientation. However, this list is not exhaustive. There are inevitably areas of content for which users have not been given blocking tools. These include pornography, violent material and other material which is subject to control in the offline world. Not only will the present list of tools need to be assessed for their thoroughness in allowing users to protect themselves from specific harms, but surely the types of harm from which they need to be protected themselves will change over time. OFCOM will need regularly to assess where these harms are and make sure that service providers regularly update their content blocking tools. Without the assessment, it would be hard for OFCOM and civil society to understand what the upcoming concerns are with the tools. This amendment will provide transparency obligation, which will demand that service providers inform users of the risks present on the platform. Surely, this is crucial when users are deciding what to protect themselves from. The assessment should also be looking for the unintended restrictions of freedom of expression created by the new tools. If the tools are overprotective, they could surely create a bubble and limit users' access to information from which they might find useful. This could mean that the user would want to block themselves from material about eating disorders, but the algorithm might interpret that to mean limiting the user's access to content on healthy lifestyles or nutrition content. We are also told the algorithms don't understand irony and humour. When the filters are being used to stop content which is abusive or incites hatred to users' particular characteristics, it might also use a filter which removes artistic, humorous or satirical content. Repeatedly, we are told that the internet creates echo chambers where users read only like-minded opinions. These bubbles can create an atmosphere where freedom of expression is severely limited and democracy suffers. A freedom of expression element to this assessment would also, in these circumstances, be critical. We're told that tech platforms often don't know what their own algorithms do, and are not surprisingly, they often evolve beyond their original intentions. Assessments on the tools demanded by Clause 12 need to be carefully investigated to ensure they're keeping up to date with the trends of abuse on internet, but also for the unintended consequences on curbing freedom of expression, which they might create. Throughout the bill, there is a balancing act between freedom of expression and the protection from abuse. The user empowerment tools are potentially very powerful, but neither the service providers, nor the regulators, nor the government know what their effects are going to be. It is beholden upon the government to introduce an assessment to check regularly how the user empowerment duties are working. Otherwise, how can they be updated? How can Ofcom discover what content is being unintentionally controlled? I urge the Noble Lord the Minister, in the name of common sense, to ensure that these powerful tools unleashed by the bill will not be misused or become outdated in a fast-changing digital world.
My Lords, I rise mainly to thank the Noble Lord Moyland. I thought I was having time travel there, and to actually be sympathetic to many of the issues he's raised, although I think maybe some of the other amendments in this group tackle it in a slightly different way. I would like to support amendments 44 and 158 in the name of the Right Reverend Prelate Bishop of Oxford. And I do see that requiring a post-rollout assessment to ensure that the triple shield acts as we are told it will seems to me to be a classic part of any regulatory regime that is fit for purpose, is to assess whether it is indeed working. The triple shield is an entirely new concept, and none of the burgeoning regulatory systems around the world are taking this approach. And I would hope that both the government and Ofcom would welcome this very targeted and important addition to the bill. I also would like to say a few words about 158 and 218. And it just does seem to me, in moving away from legal but harmful, which indeed, as a member of the pre-legislative committee, I did support under certain conditionality that has not been met, but nonetheless did support, that there hasn't been enough time and thought about what the implications of that are. And I do not understand, and I would be really grateful to the Minister if he would help me understand how it is that Ofcom is to determine whether or not a company has met its own terms and conditions. And by any means, not only by the means of risk assessment. And I do want to make a point that actually the noble lady Healy made the other day, but I want to make it again, which is that in taking legal but harmful out, and in having no assessment of whether a company has met its general safety duties, it does leave the child safety duties as an island. They used to be something that was added on to a general system of safety. Now they are the first and only port of call. And so again, I think because of the way that legal that harmful fell out of the bill, I'm not sure whether we've totally understood how it is that the child risk assessments sit without a generally cleaned up or risk-assessed digital environment. And then finally, I wish to speak in support of 160, which is for Ofcom to say what adequate and appropriate terms are. And I do think to a large degree that's my approach to the Noble Lord Moyland's problem, is let Parliament and let the regulator determine what we want to see. As was said in the data protection regime, that is how it is, and that we have minimum standards that we can rightly expect based on UK law, as the Noble Lord was suggesting. My Lords, I'm not against the triple shield per se, but it sort of radically replaced an entire regime of assessment, enforcement and review. And I think that some of the provisions in this group really do beg government's attention to make sure that there aren't gaping holes in the regime.
My Lords, I rise also to speak to amendments 44 and 158 in this group in the name of the Right Reverend Prelate Bishop of Oxford. But I'd also like to note my support for Lord Stevenson of Balmacara with his amendments to ensure the minimum standard for a platform's terms of service, which I think my noble friend Lord Moylan has just given an excellent speech on the reasons why these amendments should be considered. I'm also aware that the next group of amendments to be debated relate to the so-called user empowerment tools. So it does seem slightly bizarre to be speaking to Amendment 44, which seeks to ensure that these user empowerment tools actually work as the government hope they work. And also that Amendment 158 seeks to risk assess, do providers' terms of service duties do what they say, and reported to OFCOM. Now, like other noble lords, the government having watered down the clauses in this bill that deal with protection for adults, I'm not necessarily against the government's replacement triple shield, but I also believe it needs a little tightening up to ensure that it works properly. And these amendments seem a reasonable way of doing just that, which would ensure greater protection for adults without impinging on others' freedom of expression. The Triple Shield relies heavily on companies' enforcement of terms of service and other vaguely worded duties, as the Noble Viscount mentioned, that user empowerment tools need to be easily accessible and effective, whatever that means. But unlike other duties in this bill, such as illegal content and children's duties, there is no mechanism to assess whether these new measures are working, nor whether the companies carrying out these duties is in accordance with the criteria set out, or whether they are indeed infringing on freedom of expression. And risk assessments, I believe, are vital to doing just that, because they are vital to understanding the environment in which services are operating. They can reduce bureaucracy by allowing companies to rule out risks which aren't relevant to them, and they increase user safety by revealing risks, new risks, and therefore also enable a future-proofing of a regime. Can the Minister give us an answer today as to why risk assessment duties on these two strands of the Triple Shield, terms of service and user empowerment tools, were removed? And if freedom of speech played a part in this, perhaps he could elaborate why he thinks undertaking a risk assessment is in any way a threat. Because without these amendments, the bill cannot be said to be a complete risk management regime. Companies will, in effect, be marking their own homework when designing their terms of service and putting their finger in the air when it comes to user empowerment tools. There will be no requirement for them to explain either to OFCOM or indeed to service users the true nature of the harms that occur on their service, and nor the rationale behind any decisions they might make in these two fundamental parts of their service. So since the government is relying so heavily on its Triple Shield to ensure protection for adults, to me, not reviewing two of the three strands that make up the Triple Shield seems like fashioning a three-legged stool with completely uneven legs, a stool that won't stand up to the slightest pressure when used, and therefore I urge the Minister to look again and consider reinstating these protections in the bill.
This group of amendments looks at the treatment of legal content accessed by adults. And the very fact that Parliament feels that legislation has a place in policing access to legal material is, I think, itself worrying. This was, of course, initially a door opened by the government in the initial draft bill, but as we've already heard, after widespread civil liberties backlash against the legal but harmful clauses, we're left with clause 65. And of course I'm worried, as has been mentioned, that this clause and indeed some of the amendments might well bring back legal but harmful for adults by the back door. And one of the weasel words here is harmful, but as I've indicated before, it's quite difficult to work out in terms of the groupings when to raise which bits. So I'm keeping that for you till later. Just to note that I'm rather nervous about the weasel word harmful. But anyway, like many others, I cheered at the removal of the legal but harmful provisions, but I do have serious reservations about its replacement of further duties via terms of service, which imposes a duty on Category 1 services to have systems and processes in place to take down or restrict access to content, to ban or suspend users in accordance with terms of service, as the Noble Lord Moylan has explained. And it's one of the reasons I support his amendment, because it does seem to me to be the state outsourcing the grubby job of censorship to private multinational companies with little regard for UK law. I put my name down to Lord Moylan's Amendment 155 because I wanted to kind of probe what the government's view is on our attitude to companies' terms of service. I mean, platforms have no obligation to align their terms of service with freedom of expression in terms of UK law. It's up to them. I'm not trying to impose upon them what they do with their service users. If a particular platform wishes to say we don't want these type of views on our platform, fine. That's their choice. But when major platforms' terms of service, which are extensive, now become the basis on which UK law enforces speech, then I get nervous, because state regulators are to be given the role of ensuring that all types of lawful speech are suppressed online, because the duty applies to all terms of service, whatever they are, regarding the platform's policies on speech suppression, censorship, user suspension and bans and so on. This duty is not restricted to so-called harmful content. It's whatever content the platform wishes to censor. What's more, Clause 65 asks OFCOM to ensure that individuals who express lawful speech are suspended or banned from platforms if in breach of the platform's T's and C's. And that means limiting those individuals in expressing themselves more widely beyond the specific speech in question. And that's a huge green light to interfere in UK citizens' freedom of expression, in my opinion. I want to stress, I'm not interested in interfering in the terms and conditions of private companies, although you'll see later that I've got an amendment demanding that they actually introduce free speech clauses. But that's because the way that we are seemingly enacting the law is via the terms of service of private companies. They should, of course, be free to dictate their own terms of service. It's reasonable that members of the public should know what they are, expect them to be upheld and so on. But that doesn't justify the transformation of these private agreements into statutory duties, and that's my concern. So I want to ask the Minister, why are we allowing this bill to ask companies to enforce censorship policies in the virtual public square that do not exist in UK law? When terms of services permit suppression of speech, that's up to them. But when they suppress speech far beyond the limitations of speech in UK law, and then they are enforced to do so by a government agency, as in, or regulator, as in OFCOM, aren't we in trouble? It means that corporate service, terms of service, which, by the way, are designed to protect platforms' business interests, are they not, are trumping case law on free speech that's involved for many years. Those terms of service are also frequently in change and in flux according to fashion or ownership. One only has to look at the endless arguments about the, and I yet to understand it, the changing terms of services in relation to Twitter after the Elon Musk takeover. Is Ofcom's job to follow Elon Musk's ever-changing terms of service and enforce it on the British public as though this is law? The T's and C's no longer are therefore simply a contract between the company and the user, but having been brought under statute, it means that big tech will be exercising public law functions, with Ofcom the enforcer, ensuring that lawful speech is suppressed constantly in line with private companies' terms of service. This seems to me to be an utter mess, not in any way adequate at protecting free speech, and really a fudge by the government because they were unpopular on lawful but harmful, so they've simply outsource it to someone else to do the dirty work.
Lords, I must say it's been very interesting to hear so many noble lords singing from the same hymn sheet, especially after this weekend, my lords. My noble friend Lord McNally opened this group by giving us his very wise perspective on the regulation of new technology. And back in 2003, as he mentioned, the internet was not even mentioned in the Communications Act. And he explained how regulation struggles to keep up and how quantum leaps come with a potential social cost, my lords. All that describes how important, I believe, risk assessment of these novel technologies is, my lords. And the government, as we've heard from many noble lords today, at Commons report stage, made a decision to remove the adult safety duties, the so-called legal but harmful aspect of the bill. And as we've heard, and I agree with many noble lords who've expressed this has significantly weakened the protection for adults under the bill. And I share the scepticism of many noble lords expressed about the triple shield. Now, this group of amendments, right across the board with one or two exceptions, rightly, in my view, aims to strengthen the terms of service and user empowerment duties within the bill to provide a greater baseline of protection for adults without impinging on others' freedom of speech, and to reintroduce some risk assessment requirement on companies. And the new duties will clearly make the largest and riskiest companies expend more effort on enforcing their terms of service for the UK users. But the government hasn't really yet presented any modelling on what effect this will have on companies' terms of service. And I must admit, I have some sympathy with what Lord Moylan had to say. It could be that the effect of the new duties will mean that terms of service will become much longer and lawyered. This might have an adverse effect on freedom of expression, leading to the use of excessive takedown measures rather than looking at other more systemic interventions to control content such as service design. And we heard much the same argument from the noble Baroness Fox. And it seems to me that they made a very, very good case for some of the amendments that I'm going to be talking to this afternoon, my lords. On the other hand, companies that choose to do nothing will have an easier life under this regime. And faced with stringent application of the duties, companies might make their terms of service shorter, cutting out harms that are hard to deal with because of the risk of being hit with enforcement measures if they don't. So far from strengthening protections via this component of the Triple Shield, the bill risks weakening them with particular risks for vulnerable adults. And as a result, my lords, I very strongly support amendments 33AB and 43ZA that my noble friend spoke to at the very beginning of this debate last week. Like the noble Baroness Kidron, however, I very strongly support amendments 154, 218 and 160 in the name of Lord Stevenson, which puts a requirement on regulated services to maintain, quotes, adequate and appropriate terms of service, including provisions covering the matters listed in section 12, my lords. Amendment 44, in the name of the Right Reverend the Bishop of Oxford and myself, inserts a requirement that services to which the user empowerment duties apply must make a suitable and sufficient assessment of the extent to which they have carried out the duties in this section, including in each assessment material changes from the previous assessment, such as new or removed user empowerment features. And I thought that the noble Viscount Colville spoke very well, as indeed so did the noble Baroness Fraser and Baroness Kidron to that amendment, my lords. And Amendment 158 in our name inserts a requirement that services must carry out a suitable and sufficient assessment of the extent to which which they have carried out the duties under sections 64 and 65, ensuring that assessment reflects any material changes to the terms of service. Now, my Lords, that seems to be a very good way of meeting some of the objections that we've heard to Clause 65 today, my Lords. And these two amendments focus on risk assessment because the new duties do not currently have an assessment regime to work out whether they work or not, unlike the illegal content and children's duties, as we've heard, my Lords. Risk assessments are vital to understanding the environment in which the services are operating. A risk assessment can reduce bureaucracy by allowing companies to rule out risks which are not relevant to them, and it can increase user safety by revealing new risks and future-proofing a regime. Now, my Lords, the government has not yet provided adequate explanation of why, whether in the Commons or in meetings with ministers, my Lords, any proper explanation of why risk assessment duties have been removed along with the previous adult safety duties, and they've not explained in detail why undertaking a risk assessment is in any way a threat to free speech. My Lords, the government is currently expecting adults to manage their own risks without giving them the information they need to do so, depriving users of basic information about the nature of harms on a service prevents them from taking informed decisions as to whether they want to be on it at all, my Lords. Without these amendments, the bill cannot be said to be a complete risk management regime, my Lords. There will be no requirement to explain to OFCOM or users of their service by companies the true nature of the harms that occur on their service, nor the rationale behind the decisions they have made in these two fundamental parts of their service. My Lords, this is a real weakness in the bill, and I very much hope that the Minister will listen to the arguments being made this afternoon.
My Lords, I'd like to thank noble Lords from all sides of the House for their contributions today and for shining a light on the point that the noble Lord, Lord Clement Jones, mentioned as he was coming to the end of his remarks about the need to equip adults with the tools to do the job to protect themselves. And it is helpful to have these amendments here today because I think they give the noble Lord the Minister the opportunity to accept, as I hope he will, a number of the points that have been raised. It seems a long time since the noble Lord McNally introduced this group, but clearly it's given us all much time to reflect, and I'm sure we will see the benefits of that in the response from the noble Lord Minister. Much of the debate before now has focused on child safety and general practicalities, but this group helpfully allows us to focus on adults and the operation of the government's replacement for the legal but harmful section of the bill. And as the noble Lady Baroness Fraser rightly said, that perhaps some tightening up of the legislation before us would be helpful, and these amendments, I believe, give us that chance. My noble friend Lord Lipsey has put forward a number of amendments which helpfully focus on the whole area of adult risk assessments, which were required under the previous iteration of the bill, but have since been drastically watered down. And I would be grateful if the noble Lord the Minister could give some explanation as to why we find ourselves in that situation, and perhaps takes the opportunity to pick up a number of the points that are raised in the amendments. Quite a lot of the debate has focused around the amendments put forward in the name of the Right Reverend Prelate, the Bishop of Oxford. And these amendments take a somewhat different approach because they require service providers to assess the extent to which their user empowerment tools are meeting the obligations laid out in Clause 12. And the noble Lord Viscount Colville, in his helpful remarks, said that it was right to keep up to date in the trends in terms of abuse. And this is a point that I think has come up repeatedly in the course of our discussion the need to make sure that this legislation is entirely fit for purpose and is able to move with the kind of changes that the noble Lord Viscount Colville referred to. My noble friend Lord Stevenson has 4 very helpful amendments in this group which focus on the minimum standards in terms of platforms, terms of service, and it's an area that we did begin to probe during a debate last week, where the answer seemed to be that because terms of service are already complicated, we should not add to them. I think that the issue here really is about how we get the terms of service in the right place, and all of these amendments again take us to there. I was interested in the comments by the noble Lord Moylan about enforceability, but again for me on the issue of terms of service, the problem is inconsistency of terms of service, and what I believe we should be seeking to do is to bring consistency as well as usefulness and applicability into those terms of service. My Lords, we will come on to broader amendments about user empowerment tools in the next group, but there clearly is a gap between what the government has promised adult users and what they are likely to end up with when the new regime is fully operational, and I hope that we will hear from the noble Lord the Minister how perhaps that gap may be closed. I listened with great interest to the noble lady Baroness Fox, and I feel that it's important to say that I believe that the issue here is whether it's algorithms that should be powering the amount and the nature of the materials that comes the way of users. Because the amendments that we're talking about seek to assist users to have that control, not just to be at the mercy of algorithms. It isn't about individual pieces, it is about what it is that people can have control on. So I feel that the amendments that we've got are useful in that respect, because we know that there is much legal content which is carrying risk of harm to adults, and particularly vulnerable adults who are not actually being helped by this bill. And we do need confidence that filters and other empowerment tools will make a genuine difference. So I would say to the noble Lord the Minister, I hope that he will accept that a number of these amendments are particularly helpful in strengthening the bill, and that he will find a way to accept that form of strengthening.
Well, I'm very grateful to the noble lords who've spoken on the amendments in this grouping, both this afternoon and last Tuesday evening. As this is a continuation of that debate, I think my noble friend Lord Moylan is technically correct still to wish the noble Lady Baroness Kieran a happy birthday, at least in procedural terms. But we've had a very valuable debate over the course of both days on the bill's approach to holding platforms accountable to their users. Amendments 33B, 41A, 43ZA, 138A and 194A in the names of the noble lords Lord Lipsey and Lord McNally, and Amendment 154 in the name of the noble Lord Stevenson of Balmacara, seek to bring back the concept of legal but harmful content and related adult risk assessments. They reintroduce obligations for companies to consider the risk of harm associated with legal content accessed by adults. As noble lords have noted, the provisions in the bill to this effect were removed in another place after careful consideration in order to protect freedom of expression online. In particular, the government listened to concerns which were raised making the point that the previous legal but harmful provisions could create incentives for companies to remove legal content from their services. In place of adult risk assessments, we introduced new duties on Category 1 services to enable users themselves to understand how these platforms treat different types of content, as set out in clauses 64 and 65 of the bill. In particular, this will allow OFCOM to hold them to account when they do not follow through on their promises regarding content they say they prohibit or to which they say they restrict access. Major platforms already prohibit much of the content listed in Clause 12, but these terms of services are often opaque and not consistently enforced. The bill will address that and change that. I would also like to respond to concerns raised through Amendments 41A and 43ZA, which seek to ensure that the user empowerment categories cover the most harmful categories of content to adults. I want to reassure Noble Lords that the user empowerment list reflects input from a wide range of interested parties about the areas of greatest concern to users. Platforms already have strong commercial incentive to tackle harmful content. The major technology companies already prohibit most types of harmful and abusive content. It's clear that most users do not want to see that sort of content, and most advertisers do not want their products advertised alongside it. Clause 12 sets out that providers must offer user empowerment tools for the specified list of content to the extent that it is proportionate to do so. This will be based on the size or capacity of the service, as well as the likelihood that adult users will encounter the listed content. Providers will therefore need internally to assess the likelihood that that users will encounter the content. If Ofcom disagrees with the assessment that a provider has made, it will have the ability to request information from providers for the purpose of assessing compliance. Amendments 44 and 158, tabled by the Right Reverend Prelate the Bishop of Oxford, seek to place new duties on providers of Category 1 services to produce an assessment of their compliance with the transparency, accountability and freedom of expression and user empowerment duties as set out in clauses 12, 64 and 65, and to share their assessments with Ofcom. I'm sympathetic to the aim of ensuring that Ofcom can effectively assess companies' compliance with these duties, but these amendments would enable providers to mark their own homework when it comes to their compliance with the duties in question. The bill has been designed to ensure that Ofcom has responsibility for assessing compliance and that it can obtain sufficient information from all regulated services to make judgments about compliance with their duties. The Noble Baroness Kidron asked about this, and I see the Noble Lord Clement Jones is about to.
Forgive me for interrupting the Minister, but wouldn't it be the case that it would be much easier for Ofcom to assess compliance if a risk assessment had been carried out?
Well, I've come to say a bit more about how Ofcom goes about that work. The bill will ensure that providers have got the information that they need to understand whether they're in compliance with their duties under the bill. Ofcom will set out how providers can comply in codes of practice and guidance which it publishes. That is information which will help providers to comply, though they can take alternative action if they wish to do so. The amendments in the name of the Right Reverend Prelate also seek to provide greater transparency to Ofcom, and the bill's existing duties already account for this. Indeed, the transparency reporting duties set out in Schedule 8 will already enable Ofcom to require Category 1, Category 2A and Category 2B services to publish annual transparency reports with relevant information, including about the effectiveness of the user empowerment tools, as well as detailed information about any content which platforms prohibit or restrict and the application of their terms of service. Amendments 159, 160 and 218, tabled by the Noble Lord Stevenson, seek to require user-to-user services to create and abide by minimum terms of services recommended by Ofcom. The bill already seeks detailed and binding requirements on companies to achieve certain outcomes. Ofcom will set out more detail in codes of practice about the steps providers can take to comply with their safety duties. Platforms' terms of service will need to provide information to users about how they're protecting users from illegal content and children from harmful content. These duties and Ofcom's codes of practice ensure that providers take action to protect users from illegal content and content which is harmful to children. As such, an additional duty to have adequate and appropriate terms of service, as envisaged in the amendment, is not necessary and may indeed undermine the illegal and child safety duties. I've previously set out why we don't agree with requiring platforms to set terms of service for legal content. In addition, it would be inappropriate to delegate this much power to Ofcom, which would, in effect, be able to decide what legal content adult users can and cannot see. Amendment 155, tabled by my noble friend Lord Moylan, seeks to clarify whether and how the bill makes the terms of service and foreign-run platforms of foreign-run platforms enforceable by Ofcom. Platforms' duties under Clause 65 only apply to the design, operation and use of the service in the United Kingdom and to UK users as set out in Clause 65, subsection 11. Parts or versions of the service which are used in foreign jurisdictions.
Both in relation to that, Minister, in an earlier reply that you made, you said the Minister explained that platforms already remove harmful content because it's harmful and because advertisers don't like it and users don't like it. But I wondered if you could tell me what definition of harm you think you're using, because presumably different companies will have a different interpretation of harmful. And how does that work then? Because that would mean that legal speech will be required by UK law to be removed based on a definition of harmful speech that's been designed by who? Silicon Valley executives? I mean, UK law is being used to implement, this is the problem, the removal of content based on decisions that are not part of UK law, but with implications for UK citizens who are doing nothing unlawful.
The noble lady's point really gets to the heart of the debate we've had here. I was saying earlier about the commercial incentive that there is for companies to take action against harmful content, which is legal, which users don't want to see or which advertisers don't want their products to be advertised alongside. But there is also a commercial incentive to ensure that they're upholding free speech and that there are platforms on which people can interact in a less popular manner, and that advertisers that want to advertise products legally alongside that are able to do so. So there is as ever with anything that involves the market, there is the majority has a louder voice, but there is room for innovation for companies to provide minority products which cater to minority tastes within the law.
My noble friends explained very clearly how terms of service would normally work, which is a business, as I said myself, might write its terms of service to its own advantage, but it can't do so too egregiously or it will lose its customers, and businesses may aim themselves at different customers. All this is part of normal commercial life. It's understood. What my noble friend hasn't really addressed is the question why uniquely and specifically in this case, especially given the egregious history of sort of censorship by Silicon Valley, he has chosen to put this into statute rather than leave it as a commercial arrangement, and to make it enforceable by Ofcom, so that, for example, it would have been Ofcom's obligation when my right honourable friend David Davis was removed from YouTube for his remarks about COVID passes. It would have been Ofcom's obligation not to vindicate his rights to free speech, but to cheer YouTube on and say how well they've done for their terms of service.
Content was re-uploaded, and makes the point that the problem at the moment is the opacity of these terms and conditions, what platforms say they do and what they do does not always align. The bill makes sure that users can hold them to account for the terms of service that they publish, so people can know what to expect on platforms and have some form of redress when their experience does not match their expectations. I will come to say a little bit more about that after making some points about the foreign jurisdictions and my noble friend's Amendment 155, which, as I say, parts or versions of the service which are used in foreign jurisdictions and not in the UK are not covered by the duties in Clause 65. As such, the bill doesn't require a provider to have systems and processes designed to enforce any terms of services not applicable in the UK. In addition, the duties don't give powers to OFCOM to enforce a provider's terms of service directly. OFCOM's role will be focused on ensuring that platforms have systems and processes in place to enforce their own terms of service consistently, rather than assessing individual pieces of content. Requiring providers to set terms of service for specific types of content suggests that the government views that type of content as harmful or risky. That would encourage providers to prohibit such content, which would of course have a negative impact on freedom of expression, which is not what my noble friend, I'm sure, wants to see. Freedom of expression is essential to a democratic society, and throughout the passage of the bill, the government has always committed to ensuring that people can speak freely online. We are not in the business of indirectly telling companies what legal content they can and cannot allow online. Instead, the approach we have taken will make sure that platforms are transparent and accountable to their users about what they will and will not allow on their services. Clause 65 recognises that companies as private entities have the right to remove content which is legal from their services if they choose to do so. To prevent them from doing so by requiring to balance this against other priorities would have perverse consequences for their freedom of action and expression. It's right that people should know what to expect on platforms and that they're able to hold platforms to account when that doesn't happen. On that basis, I do invite the noble lords who have amendments in this group to withdraw them.
My Lords, in opening his remarks, the Minister referred to the debate opening last Tuesday. Well, it did in the fact that I made one 10-minute opening speech and Baroness Stoll rather elegantly hopped out of this group of amendments. Perhaps he saw what was coming. But it was something that I did feel perhaps best summed up by what Lord Howe said earlier today when he was justifying the business for tomorrow. He said, adjournments are never satisfactory. And in that spirit, I wrote to the Leader of the House expressing the grumbles that I made in opening my remarks. And he has written back in a very constructive and thoughtful way. And I'll not delay the House any longer, other than to say that I would hope that the Leader of the House would agree to put his reply to me in the House for other members to read, because I think it says some interesting things about how we manage business. It sounds small, but if what happened on Tuesday had happened in other circumstances in the other place, you would probably have had business delayed for at least an hour while the usual suspects picked hold in our business. And I think if usual channels will look at it, we could avoid some car crashes in the future. That apart, I'm very pleased that the group of amendments we put forward have elicited such an interesting debate with, I would say to the Minister, fire coming from all sides. In introducing the debate, I said probably the only real advice I can give to the House comes from my experience from being on the 2003 pre-legislative scrutiny, was just how little we were prepared for the revolution, the tsunami that was about to engulf us in terms of new technology. The one pleasure I have is that we were part of forming OFCOM, and I'm very pleased that the chairman of OFCOM, Lord Grade, has assiduously sat through our debates. I suspect he's sitting there thinking, I better hire some more lawyers, because what we're trying to do here is to get it right. I don't think there's any doubt that all sides of the House want to get this legislation through in really good shape to play an important role. I'm not as afraid of... I'm sure Lord Grade never imagined he'd become a state regulator in the kind of ominous way that Baroness Fox says it. I think Ofcom has done a good job and will do a good job in the future. But this problem of getting definitions right, I know when I was in the ministers, I'm not a lawyer. When I was at the Ministry of Justice, I once had to entertain a very distinguished American lawyer, and as I usually said, I must explain to you, I'm not a lawyer. And he looked at me and said, then I'll speak very slowly. And there is a danger, particularly in this part of the bill, that we were wandering into a kind of lawyer fest. And it's important that we get what powers we're giving to whom very precisely. I remember being warned as well, just to chill the minister's soul, about Pepper and Hart, and that what he says at that dispatch box will be used to interpret what Parliament meant when it's giving this or that power. But I think that it is the debate we've had thus far has been fully justified in giving a few kind of warning signals to the Minister that perhaps it isn't quite right yet and needs further working on. There's a lot of goodwill on all sides of the House to get it right. But for the moment, I beg leave to withdraw.
Is it your Lordship's pleasure the amendment be withdrawn? The amendment is by leave withdrawn.